Honorable Supreme Court of the State of North Dakota is now in session.
Good afternoon. Please be seated. We are here at the time set for oral argument in file number 2025-0393, Shannon Gjovig versus Tierney Johnson, versus New Century Ag. Sitting today are Justices Jared Tufte, Justice John Jensen, Justice Douglas Barr, and Justice Mark Fries. I am Lisa Fair-McEvers. Arguing this afternoon for the appellant is Sean Grinolds, and I see that you have 10 minutes reserved for rebuttal. Is that correct, Mr. Grinolds?
That's correct.
And for the appellee, Matthew Lawless?
Correct.
Okay, thank you. Mr. Grinolds, you may proceed when you're ready.
May it please the court, counsel. My name is Sean Grinolds. I'm here representing the plaintiffs' appellants Shannon Gjovig and Tierney Johnson. Gjovig and Johnson allege that the defendant appellee New Century Ag was negligent in its selection and application of a mixture of herbicides which were applied to their lentil crops on June 14th and 15th of 2023, which resulted in total destruction of their crops. The district court granted New Century Ag's motion for summary judgment on the sole basis that their failure to serve New Century Ag with notice of their crop damage claim by certified mail pursuant to North Dakota Century Code Section 4.13318. Despite finding that New Century Ag's agronomist observed the crop damage and called Shannon Gjovig to report his observations on June 25th, 2023, only 11 days after the crops were sprayed, and reported his observations that the crops were dead or sick, and despite finding that New Century Ag's insurance adjuster examined the fields with Gjovig and Johnson on July 24th, 2023, 28 days later, and observed the dead lentils with opportunity to take samples and pictures, the district court concluded the notice by certified mail provisions by certified mail was mandatory and dispositive of the case, citing this court's decision in Laufer versus Doe, 2020, North Dakota 159. At issue on this appeal is whether strict adherence to the notice by certified mail provision of North Dakota Century Code Section 4.13318 to the specific facts of this case has led to an absurd or ludicrous or unjust consequences contrary to the intended objective of the statute. This court has previously determined that in Laufer versus Doe that the main objective of the statute is to ensure that the defendant is notified in a timely manner so he can inspect the damage allegedly caused by spraying before the evidence becomes impossible to obtain. The evidence in this case establishes New Century Ag itself discovered and notified Gjovig of the crop damage 11 days after New Century Ag's application of the chemicals, and New Century Ag had its crop insurance adjuster inspect the affected fields with Gjovig and Johnson and had the opportunity to take samples and pictures 28 days later while the evidence was still obtainable. The main objective of the statute was met in this case. So the statute at issue is Section 4.13318, and that's reproduced in the appellant's brief at paragraph 19 on page 10. The relevant provisions of that statute at issue here today provides in subsection 1A, before a person may file a civil action seeking reimbursement for property damage allegedly stemming from the application of a pesticide, the person shall notify by certified mail the pesticide applicator of the alleged damage within the earlier of 1, 28 days from the date the person first knew or should have known of the alleged damage, or before 20% of the crop or field allegedly damaged is harvested or destroyed.
Mr. Grinolds, let me stop you there. Is it your position that this is an ambiguous statute?
We're not arguing that the language of the statute is ambiguous. We're arguing that...
But you're arguing that asking us to rewrite it.
We're not asking you to rewrite it either. We're just saying that strict application of the statute to the facts of this case do not reflect the objective of the statute as what the legislature intended.
And if the legislature wanted exceptions, it could have easily put those in the statute, correct?
They could have made exceptions in the statute, and they didn't.
So you're asking us to judicially make exceptions that the legislature did not?
No, what we're saying is that this court has said in Laufer versus Doe in regards to the statutory construction rules that you always assume that the legislature did not intend a ludicrous or absurd result. So there's two tests. One, is it ambiguous, or does the strict adherence to the letter of the statute result in absurd or ludicrous result or unjust consequences? And so we're arguing the latter of those. Under the facts of this case, one thing I will note is that the only case this court has ever reviewed and interpreted the statute under is Laufer versus Doe. You've had prior cases interpreting prior versions of the statute, but what distinguishes this case from all of those cases is that in none of those prior cases was there a situation where the applicator was notified and actually inspected the crops with an insurance crop adjuster, in this case, within the timeframes contemplated by the statute. The 28-day notice period under the statute only pertains to the timeframe within which the applicator is to be notified. It doesn't apply to the timeframe within which the actual inspection or observation of the damage is to occur, which appears in subsection 2 of that statute. And so the basic premise of our argument is that what's the point of the notice by certified mail specifically provision when, in this case, the applicator actually was able to and did go out and inspect the crops while the evidence was still obtainable and had the opportunity to take samples and photographs?
What about the circumstance where the applicator drives by, sees the damage to the lentils, has actual knowledge, but nobody's ever called them? Would you extend this statute to cover that type of eventuality as well?
No, our argument is that if it's a combination of, the only thing we're arguing about on the statute is that there shouldn't be strict adherence to the certified mail aspect of the notice requirement where
So contacting the applicator's wife by telephone would be sufficient?
if the applicator actually turned around then and went out and actually inspected when the evidence was still available. See, our point is that the main objective of the statute is to give the applicator the opportunity to go out and to preserve the evidence before the evidence is destroyed. Once that's happened, what difference does it make how they got the notice of the claim in the first place? In this case, the applicator is the one who noticed the damage, contacted us about the damage, and then followed up with actually having an insurance crop adjuster go out there and inspect the fields with our clients, had the opportunity to take samples and photographs while the evidence was still available. Our argument is that that meets what the intent, what the legislature intended, what the objective of the statute was.
But couldn't there be other purposes for the certified mail requirement? Having documentation, if there's a factual dispute, it can be resolved. Claims of somebody that they didn't receive proper notice. It's more than just to give notice to start the mechanism to inspect the crops.
So in that regard, we agree. If there hadn't actually been an inspection by the crop insurance adjuster when the evidence was still freely available to be inspected and preserved.
So then a crop adjuster with actual notice could just delay till the 28 days expires and then undermine the argument that you're advancing.
That's true. Let's say, correct. So our point is that the certified mail, the notice requirement does make sense to have some mechanism for proving how notice was provided if there isn't a subsequent actual inspection where you actually preserved or they had the opportunity to preserve the evidence. Because once you have the opportunity to preserve the evidence, that kind of moots the whole issue of the notice, because obviously you got notice if you're out there and you're actually preserving the evidence, which is the main objective of the statute. Now, I'll note that the statute does say certified mail notice. Well, that can't possibly be essential to achieving the main objective of the statute. What if you had the sheriff go out there and personally serve them with a written notice of your claim? Under the statute, that technically wouldn't comply, but that would still, again, lead to a ludicrous result. So I guess that's our point, is that once they've actually went out there and had the opportunity to preserve the evidence before the evidence is destroyed, how the notice was provided is really a moot point at that point. So strict adherence to the certified mail notice aspect of the statute is what's causing the ludicrous result under the facts of our case. Again, our case is unique from all the other cases you've reviewed interpreting this statute and prior versions of the statute. For instance, in Laufer versus Doe, in that case, the property owner only called the applicator and told him of his property damage. There's nothing in that case or in the record that establishes that applicator ever did come out and inspect the crops when the evidence was still available for preservation purposes, or was even afforded the opportunity to do that. That's not reflected in the decision in that case. Similarly, with the prior version of the statute under Dickinson Air Service versus Cattermiss, in that case, the property owner was complaining about his crops were sprayed. After his crops were sprayed, he noticed that the tree line along his fields, the Russian olives were starting to have effects from the spray. He contacted an expert to come out and look at it. He didn't contact Dickinson Air Service about the damage. He had experts come in. This went on for several months before he finally filed and served on the applicator a verified statement of loss, which at that time was a requirement. He had to serve the applicator both with the verified statement of loss and file it with the North Dakota Department of Agriculture. The different scheme, but even back then, there was no specified form of notice that the statute required. It just said you shall serve notice upon. And in those days, as reflected in the legislative history of this statute and prior versions thereof that I've submitted to the court under paragraphs 23 to 25, testimony before the legislature by the Department of Ag noted that, farmers are not understanding this concept of notice. We are helping them effectuate notice. And even under that version of the statute at that time frame, it required the applicator to actually tell the farmer, by the way, you've got to follow this verified statement of loss mechanism in order to pursue a claim on this thing. And the statute at that time specifically said if the applicator fails to tell the farmer about this requirement, that the 60-day period at that time within which to give notice didn't even apply, and the applicator could potentially lose their license over the issue. So the whole point is that the statute was never intended to be a gotcha. The whole point was to have a mechanism by which applicators were given timely notice so they have a chance to go out and preserve the evidence. That's been the whole underlying focus of the statute from the very beginning, from when even the earlier versions were passed. Ultimately, the Department of Ag got out of it entirely, convinced the legislator to change the law because it was too time-consuming to be hand-holding everyone on this whole process on the verified statement of loss, which is discussed in the legislative history that I have in the appellant's brief. So, aside from the main objective and the legislative history, and the fact that Laufer versus Doe and all the prior cases are factually distinguishable from the cases we have here, one thing I'll note is that in Laufer versus Doe, the court concluded that certified mail provision is mandatory because of the use of the word shall. Now, when the court said that, the court basically said that certified mail, service by certified mail serves the main objective of the statute, which ensures the defendant is notified in a timely manner so he can inspect the damage allegedly caused by spraying before the evidence becomes impossible to obtain. That's Laufer at paragraph 17. But in the Laufer decision, in explaining the rules of statutory construction to be applied, specifically noted that in determining whether shall was mandatory, noted that, quote, if the duty prescribed in the statute is essential to its main objectives, the word shall is to be construed as creating a mandatory duty, unquote. That's Laufer at paragraph 16. And that's our argument here, is that while certified mail may be consistent with and may foster the objective of giving timely notice to the pesticide applicator, is certainly not essential. As I said, what if a sheriff personally served the notice on the applicator? The same objectives are being achieved in that case. And ultimately, if the applicator gets out there and actually inspects it and has an opportunity while the evidence is still there, the objectives of the statute are also being met in that situation.
Mr. Grounds, I have a question. The language you're relying on is when we interpret a statute, if adherence to the strict letter of the statute would lead to an absurd or ludicrous result. That's for interpreting the statute. You're asking us to use that language to apply it factually in every individual case, correct? You're not asking us to interpret the statute. You're asking us to make an exception in this individual case. Because in this case, you argue there's a ludicrous result.
We are arguing that the absurd or ludicrous result language of that rule of statutory construction pertains to how the impact of the unambiguous language of the statute applies. In other words, because the way it's worded.
You're arguing that's not to interpret the statute generally, it's case-specific.
That would
So
be.
every single case, someone can come in and make it a factual issue.
Well, they could, I would have to say yes, because the ambiguity, you look at the language of the statute on its face, and is it a clear meaning on its face? The second part, or if adherence to the strict letter, which means an unambiguous strict letter of the statute, then we assume that the legislature didn't intend the result. That's how I interpret that rule of statutory construction, is that if it, as applied to a certain set of facts, if it's such an absurd or ludicrous result, the legislature couldn't possibly have intended that when they enacted the statute. Yes, that is what our argument is in this case.
So it's not generally to interpret the statute, it's to interpret it how we're going to apply it in
Correct.
each individual case.
I would agree, because otherwise, it's the same as the ambiguity argument then, right? Because if it's a ludicrous argument as to how the
But a
word-
statute could be unambiguous and still, on its face, reach an absurd and ludicrous result.
Correct, and that's what we're arguing in this case, that it's
You're
not-
arguing it only under the facts of this case, it's absurd, not under 99% of the other cases.
We are arguing in the facts of this case, it leads to a ludicrous or absurd result. That is correct.
Mr. Reynolds, if we agree with you, how many cases will we have to overturn, if any? Will we have to overturn Lawfer?
No, because in Laufer, as it's factually distinguishable. In that case, there was no evidence that the applicator was ever given the opportunity or did actually inspect the crop before the evidence was destroyed, which is the main objective of the statute. All he did was he called. And that's, again, where some proof of service of the notice of claim does make sense in cases where there actually hasn't been a follow-through and there's actual inspection of the underlying crop, because the issue then is, since it hasn't been inspected yet in a timely fashion to preserve the evidence, the question then becomes, well, did you actually give him sufficient notice so he had the chance to do that? And that's where the certified mail notice or whatever notice provision would apply and comes into play, because then you have the proof issue. Well, how do you prove that you actually gave him notice and an opportunity? In our case, it's a moot point. They actually came out there, inspected and observed and had the opportunity to preserve the evidence.
And where would you draw the line? When they actually came out and inspected, or if they had the opportunity? So 3 days after the application, damage is noted, the applicator is advised of it, but they don't take the opportunity over the next 25 days. Isn't the next logical step, it would be ludicrous in application because the applicator didn't inspect when they had the opportunity to do so?
So our argument is that it's only when they actually go out and inspect that the notice provisions then become mooted. Because what difference does it make how they got their notice? They actually went out there and they did their full inspection and had the opportunity to inspect. It's when they don't actually go out there and have an opportunity to preserve the evidence, then the issue is, well, did you give them sufficient notice so they had the opportunity to do so? And that's where the statute says certified mail. I would argue in some cases, like if it's a sheriff is one who's doing it, but the point is the manner of service too isn't the focus of the statute. I believe the legislature, the intent was to have the opportunity to preserve evidence. Does it really matter if it's certified mail, if it's a sheriff who serves them? That's our point.
Mr. Reynolds, if I recall correctly, your case addressed and distinguished Chapter 3212.2 that addressed notice of claims against the state, where there's strict compliance is required. If we accept your client's position in this case, doesn't that call into question everything under that statute too? Because you can say, well, you had actual notice, you knew actually the amount of damages, the same slippery slope of, now it's a factual issue on every single case. What do they know, whether or not they knew it, and whether you actually gave notice no longer becomes relevant, it becomes what happens later.
So again, it comes down to what's the main objective of the statute. If it's claims against the state, obviously you have the issue of sovereign immunity. And by the North Dakota Constitution, you can only bring claims against the state as permitted by the legislature. And so the legislature has enacted this statutory scheme by which you can bring claims against the state. And it's a little different situation too when you're involving the state. The state's a large organization. They get a lot of paperwork every single day. And the issue is, how do you funnel that to, how do you effectively make sure the right people are being notified of the claim?
But if the state knew, if they knew the amount of damages and it served all the purposes of notice, despite there being no notice, under your argument, then the claim can proceed despite non-compliance.
Our position is that it's distinguishable because the issue of sovereign immunity and because the legislature can specify, because of sovereign immunity, only they can specify the mechanisms by which the state can be sued. Our position is that it's just a different situation. We are dealing with claims between private litigants and claims against the state. And I guess ultimately, I just want to point out, I've got a few seconds left here, is that ultimately the district court granted summary judgment on the sole basis of this certified mail notice issue. Questions of fact still remain in this case. If the court agrees with our position, this should be kicked back to the district court for resolution.
Thank you, Mr. Grunholz. Mr. Lawless?
Good afternoon, and may it please the court. Matthew Lawless from Fisher Byrne Sheridan on behalf of New Century Ag. I'll go ahead and state that I'm recovering from a cold, so if I'm mumbling or you can't hear me, please let me know and I'll do my best. The issue before the court today is resolved by a single undisputed fact, and that is the undisputed fact that written notice by certified mail was never provided in this case. There is no other fact of any relevance to this court's decision other than that fact today. Under the statute and under this court's unanimous decision in Lawfer v. Doe, that admission of fact is dispositive. As I stated, there are no facts, real or hypothetical, that could be put forth today or discovered in further discovery if it were ordered that would change that outcome. New Century Ag respectfully requests that this court affirm the trial court's dismissal of the appellant's claims under North Dakota Century Code 4.13318. It's important to note that the statute that we are addressing here today, the language of that statute was adopted in 2007 under the predecessor statute of the statute we're discussing today. In drafting and adopting that statute, the North Dakota legislature intentionally and deliberately made two changes to the statute. One is that they deliberately and intentionally added the requirement that notice be provided by written notice be provided by certified mail. The second deliberate and intentional addition to the statute that did not exist prior to 2007 was to grant the chemical applicator a right of entry to the property to inspect. But they made that right of entry conditional upon the receipt of written certified notice. If we were to adopt the appellant's arguments here today, we would effectively be stripping the chemical applicator of that right to inspect under subsection 2 of the relevant statute. And that is because, as the court has discussed with the appellant, there are situations where an applicator may become aware or otherwise may receive certain notice of damage to property, but then be precluded from inspecting that property as they are afforded the right to do under subsection 2 of the statute.
But this is not one of those circumstances, correct? Your client did have the opportunity to inspect.
I'm glad you brought that up because that is not factually accurate. Today, the only record that is really before the court that is of any material relevance to the question today are the plaintiff's answers to written discovery, as well as the declaration of Tyranny Johnson that was supported in support of the opposition to the motion for summary judgment. Really, there's no other evidence that's available to the court other than those two documents. Importantly, in the appellant's responses to written discovery, they do not claim that they ever contacted New Century Ag in relation to the property damage. Instead, on June 26th, New Century Ag contacted the appellants and said, hey, I saw this from the roadway. There may be some potential issues. Do you have time to talk? And the response, according to appellants, was, yes, I already saw that. I saw it before I left for vacation, but I didn't contact you. They also state that they promised to call them when he returned from vacation, but he didn't. Mr. Gjovig did not contact New Century Ag at any time after returning from vacation. Instead, on July 11th, after hearing nothing, New Century Ag contacted the appellants and said, hey, I'm following up on this. New Century Ag drove to the house to gather information, and the response that they got from appellants was, I don't have time to talk, go away. The only time that New Century Ag was able to get any information was during the July inspection. But that July inspection was more than 28 days from the date that the appellants knew or should have known of the property damage. Excuse me. Ultimately, whether or not New Century Ag did or did not inspect the property damage within 28 days is irrelevant. But I also want the court to be aware that they did not inspect the property within 28 days. It was more than 28 days after the appellants knew or should have known. The appellant's argument today is fundamentally that the statute as applied to them creates an unjust or ludicrous result. But that is not the standard that we are to review statutes by. It is not on a case-by-case basis on the facts of an individual case. It is more of a question of whether or not the statute as a whole, when applied to the community, results in ludicrous or unjust results. We have statute of limitations in the state of North Dakota that affect a broad area of claims, virtually all claims in this community. The barring of a claim under the statute of limitations is not in and of itself an unjust or ludicrous result. But that is the position that the appellants are effectively taking today, that just because their claim is barred, it is unjust and ludicrous. However, this court, in its unanimous decision in Lawford v. Doe, did not find that barring a claim, even when an applicator had actual notice, was unjust or ludicrous. In Lawford, this court specifically held that even if the applicator had actual information about the property damage, it was irrelevant because the statute requires strict compliance. And the failure to provide written notice by certified mail, even if the applicator has actual information, does not save a claim if they do not comply with the statute. And that is what New Century Ag is asking the court to do today. It is to follow the unanimous decision in Lawford v. Doe. It is to require strict compliance, and it is to enforce the statute as deliberately drafted and written by the North Dakota legislature. New Century Ag asks this court to decline the invitation to rewrite that statute or to substitute its own judgment or policy in favor and override the legislature. And again, as I alluded to earlier, the issue of strict compliance, we can see why it's necessary by evaluating the statute as a whole, rather than just evaluating pieces of the statute. As I alluded to earlier, there's two effective provisions within the statute. One is the required written notice by certified mail that must be provided before a lawsuit can be filed. The second is the applicator's right to entry upon receipt of that certified notice, or notice by certified mail. If we were to adopt the appellant's position, then we would open the door to further claims of, well, the applicator knew but didn't ask to come to the property. It is the act of written notice by certified mail that is the evidence that the applicator can use to enter the property. And if we take that away, if we start applying the statute on a case-by-case basis, if we start saying that substantial compliance is close enough, then we will eventually deprive all applicators of their statutorily given right to enter the property to inspect the property damage. And that cannot be done. That right is given to the applicators to protect the applicators.
So you're arguing that one of the underlying purposes of the notice provision is to permit the applicator to enter the property, which actual notice doesn't do.
That is correct. Under the statute, subsection 2, it specifically says that upon receipt of the written notice by certified mail, the applicator is granted that right. Taken literally, and as the legislature wrote the statute, if that written notice by certified mail is not provided, the property owner has no obligation to permit the applicator onto the property. And that would render the statute effectively meaningless. If all that the applicator had, or all the property owner had to do was make a phone call and say, hey, I've got this damage, but then could preclude them from investigating the damage, it would
But
completely undermine the
doesn't that
purpose.
second subsection specifically say the claim is barred if they preclude entry? So independently, standing on its own, there are protections within that separate provision.
Right, and that is exactly our point today, is not only does it grant the applicator the right of entry upon service, or upon receipt of written notice by certified mail, but it also bars a claim if the applicator is not permitted to conduct that inspection. And to adopt the appellant's argument today would effectively undermine all of those provisions. Again, the appellant's argument today is effectively that the statute as applied to them is unjust and absurd. They are not arguing that the statute's ambiguous. They are not arguing that the statute as applied to the community as a whole results in unjust or absurd results. They're simply saying that because this statute bars their claim, it is necessarily absurd. And that is not the standard that this court is to apply. The standard that the court is to apply was very clearly announced in Law for v. Doe. And there this court, again in a unanimous decision, said strict compliance is required. Actual information, actual notice of the damage is not sufficient. And New Century Ag respectfully requests that the court apply the statute as written by the legislature, decline the invitation to rewrite that statute, and uphold the dismissal of the trial court's dismissal of the appellant's claim. So unless the court has any further questions for me, I'll yield the rest of my time.
Hearing none, thank you, Mr. Lawless.
Great, thank you.
When you're ready, Mr. Reynolds.
Justices, I guess there's several points I'd like to address based on the argument by opposing counsel. First, he argues that when the statute was last amended, they added the certified mail requirement and they added the right of entry was conditional upon receipt of the certified mail notice. He's referring to subsection 2 of the statute. However, as I argued in my opening, the 28-day notice period only pertains to subsection 1A, which is the requirement that they provided notice. And subsection 2 doesn't have any time frame under which they have to conduct their inspection. In this case, ultimately, they were actually out there and conducted the inspection. So subsection 2 was met in this case. It's not an issue. They actually did have the opportunity. They've inspected the affected fields with the owners and had the opportunity to sample and to preserve the evidence. Opposing counsel said there's no evidence in the record that they did conduct such an inspection, and that's not accurate. If you look at the declaration of Tierney Johnson's record docket 38 of paragraph 5, in that document, she specifically states Defendant agronomist contacted plaintiffs regarding the crop's condition, and representatives of defendant inspected or at least observed affected fields. Additionally, an adjuster or crop investigator working on behalf of defendant inspected the damage. New Century Ag was afforded the ability to inspect and take samples of the crop, and to plaintiff's knowledge, this occurred. So there is evidence in the record. The other thing I want to point out is that Tierney Johnson's declaration is a Rule 56F request for additional time to complete discovery. The motion for summary judgment in this case was filed well before the deadline for completion of service of written discovery or completion of depositions. No depositions were taken in this case. And so she requested additional time to conduct the discovery, and the district court essentially concluded that it wouldn't make any difference because the certified mail notice requirement is mandatory. And so since you admit you didn't serve by certified mail, that's dispositive of the case, and that kind of ended that. Opposing counsel also brought up an event that occurred on July 11th, 2023, when New Century Ag's agronomist Alan Svangsu came out to the farm unannounced on a rainy day, 30 minutes before the Shannon Gjovig was expecting company. Shannon Gjovig told him at that time, I just don't have time right now. Our position is that that's not a reasonable attempt to inspect the fields when you show up unannounced like that. Ultimately, they did get the inspection with their crop insurance adjuster, who inspected the fields and had the opportunity to preserve evidence.
And what was the date of
July,
that?
what was the question?
What was the date of that inspection that you're talking about? Because I believe Mr. Lawless said that the July inspection was more than 28 days.
Two parts of that. The inspection occurred on July 24th, 2023, which is exactly 28 days after the date that Alan Svangsu drove by and noticed the damage and called Shannon Gjovig and told him about it. It's exactly 28 days.
But your client knew about it beforehand because your client said, I'd seen it, correct?
So our client said that he saw some damage to the crops. I guess it's a question of fact as to whether that was sufficient that a reasonable person would have known that it was tied to the crop spraying before he went on vacation. We don't know what date that was, but one thing is clear. Again, the statute 28-day period runs from the date he knew or should have known. It's the 28 days for when notice of the claim of crop damage, not when the inspection occurs. So in this case, we know that New Century Ag had notice of the crop damage because their agronomist was the one on June 26th who drove by, saw the damage, and called Gjovig and told him about it. So they knew about it then, and then they followed up 28 days, within 28 days after that, which the inspection doesn't have to be within 28 days, but it just so happens to be within 28 days of that date, they did come out and they actually performed a full inspection of the affected fields. So then in Laufer, this court did say that actual notice is insufficient, but again, in Laufer, we weren't dealing with the situation with the facts like we have here, where there was an actual inspection to preserve the evidence. There was no argument in that case that the applicator actually went out and preserved the evidence or had the opportunity to preserve the evidence, or that he even went out to the fields and looked at anything. He just got a phone call. So the court wasn't directly addressing this question of whether or not application, and it wouldn't have applied in that case anyway, that application of the statute to those facts would have ended up in an absurd or ludicrous result. Then opposing counsel argues that we're arguing that the standard should only be applied to the facts as to our case. That's not really accurate. We are saying that it results in an absurd or ludicrous results under the facts of our case, but it would apply to anyone's case, where if you have the applicator actually come out and inspect and have the opportunity to preserve the evidence when it's still available for preservation. Our point is that the legislator's objective of that statute has been met. That's our position in a nutshell. If anyone has any questions, I see I have another 4 minutes. Otherwise, I'll wait my
Seeing
time.
no questions, thank you, Mr. Reynolds, for your argument this afternoon, and yours as well, Mr. Lawless. This Case will be taken under advisement, as all cases are, and court is adjourned until 10:45 on Monday, March 30th, 2026.
All right.
This is Justice Lisa Fair McEvers at the North Dakota Supreme Court. You have reached the proper location for live webcast for oral arguments of the Supreme Court. The live webcast from the North Dakota Supreme Court will begin at the time scheduled. The court's daily calendar is noted at the top of the Supreme Court's homepage. Oral arguments are normally scheduled at 9:30, 10:45, 1:30, and 2:45. 50 minutes are generally set aside for oral arguments. Arguments may go a little bit longer, and sometimes not all the 50 minutes are used for the oral argument. No decisions are announced at the oral argument, as all cases are taken under advisement. The Supreme Court will issue a written decision, usually within a few weeks of oral argument. Written opinions are posted at the Supreme Court website. Anyone can subscribe to receive free email notice of new opinions and other Supreme Court news. Simply click on subscribe on any website page. The North Dakota Supreme Court is the highest court in the state of North Dakota. It reviews the decisions of trial courts, known as district courts, and decisions from administrative agencies. The Supreme Court also decides cases involving the disciplining of lawyers and judges. There is no jury in the Supreme Court, and no witnesses are heard. The Supreme Court consists of 5 justices who are elected for 10-year terms. When there is a vacancy on the Supreme Court, the governor may fill the vacancy by appointment from a list of candidates submitted by the Judicial Nominating Committee. The Chief Justice is elected to 5-year terms by the Supreme Court justices and district judges. The Chief Justice is the administrative head of the state's judicial system. The Chief Justice is assisted by the state court administrator and other staff. The clerk of the Supreme Court receives documents for the Supreme Court. The clerk supervises the court's records in the filing, distribution, and publications of the opinions of the Supreme Court. The clerk of the Supreme Court is appointed by the Chief Justice with the approval of the other justices. The Supreme Court adopts rules used in the state's courts, including rules of civil procedure, rules of criminal procedure, rules of evidence, rules of juvenile procedure, and rules of appellate procedure. All the rules adopted by the court are found at its website. In addition to live webcasts of oral arguments, archived copies of oral arguments are available on the Supreme Court's website. The North Dakota Supreme Court's website contains the court's opinions covering many years. The site also contains a detailed directory of North Dakota licensed lawyers, biographies of state judges, listings of officials by counties and judicial districts, guides to using the North Dakota judicial system, and links to other legal resources on the Internet. A search feature is also available. In addition, court notices, proposed rules, committees, members, agendas, and minutes are also found on this website. This is Justice Lisa Fair McEvers at the North Dakota Supreme Court. You have reached the proper location for live webcast for oral arguments of the Supreme Court. The live webcast from the North Dakota Supreme Court will begin at the time scheduled. The court's daily calendar is noted at the top of the Supreme Court's homepage. Oral arguments are normally scheduled at 9:30, 10:45, 1:30, and 2:45. 50 minutes are generally set aside for oral arguments. Arguments may go a little bit longer, and sometimes not all the 50 minutes are used for the oral argument. No decisions are announced at the oral argument, as all cases are taken under advisement. The Supreme Court will issue a written decision, usually within a few weeks of oral argument. Written opinions are posted at the Supreme Court website. Anyone can subscribe to receive free email notice of new opinions and other Supreme Court news. Simply click on subscribe on any website page. The North Dakota Supreme Court is the highest court in the state of North Dakota. It reviews the decisions of trial courts, known as district courts, and decisions from administrative agencies. The Supreme Court also decides cases involving the disciplining of lawyers and judges. There is no jury in the Supreme Court, and no witnesses are heard. The Supreme Court consists of 5 justices who are elected for 10-year terms. When there is a vacancy on the Supreme Court, the governor may fill the vacancy by appointment from a list of candidates submitted by the Judicial Nominating Committee. The Chief Justice is elected to 5-year terms by the Supreme Court justices and district judges. The Chief Justice is the administrative head of the state's judicial system. The Chief Justice is assisted by the state court administrator and other staff. The Clerk of the Supreme Court receives documents for the Supreme Court. The clerk supervises the court's records in the filing, distribution, and publications of the opinions of the Supreme Court. The Clerk of the Supreme Court is appointed by the Chief Justice with the approval of the other justices. The Supreme Court adopts rules used in the state's courts, including rules of civil procedure, rules of criminal procedure, rules of evidence, rules of juvenile procedure, and rules of appellate procedure. All the rules adopted by the court are found at its website. In addition to live webcasts of oral arguments, archived copies of oral arguments are available on the Supreme Court's website. The North Dakota Supreme Court's website contains the court's opinions covering many years. The site also contains a detailed directory of North Dakota licensed lawyers, biographies of state judges, listings of officials by counties and judicial districts, guides to using the North Dakota judicial system, and links to other legal resources on the Internet. A search feature is also available. In addition, court notices, proposed rules, committees, members, agendas, and minutes are also found on this website. This is Justice Lisa Fair McEvers at the North Dakota Supreme Court. You have reached the proper location for live webcast for oral arguments of the Supreme Court. The live webcast from the North Dakota Supreme Court will begin at the time scheduled. The court's daily calendar is noted at the top of the Supreme Court's homepage. Oral arguments are normally scheduled at 9:30, 10:45, 1:30, and 2:45. 50 minutes are generally set aside for oral arguments. Arguments may go a little bit longer, and sometimes not all the 50 minutes are used for the oral argument. No decisions are announced at the oral argument, as all cases are taken under advisement. The Supreme Court will issue a written decision, usually within a few weeks of oral argument. Written opinions are posted at the Supreme Court website. Anyone can subscribe to receive free email notice of new opinions and other Supreme Court news. Simply click on subscribe on any website page. The North Dakota Supreme Court is the highest court in the state of North Dakota. It reviews the decisions of trial courts, known as district courts, and decisions from administrative agencies. The Supreme Court also decides cases involving the disciplining of lawyers and judges. There is no jury in the Supreme Court, and no witnesses are heard. The Supreme Court consists of 5 justices who are elected for 10-year terms. When there is a vacancy on the Supreme Court, the governor may fill the vacancy by appointment from a list of candidates submitted by the Judicial Nominating Committee. The Chief Justice is elected to 5-year terms by the Supreme Court justices and district judges. The Chief Justice is the administrative head of the state's judicial system. The Chief Justice is assisted by the state court administrator and other staff. The Clerk of the Supreme Court receives documents for the Supreme Court. The clerk supervises the court's records in the filing, distribution, and publications of the opinions of the Supreme Court. The Clerk of the Supreme Court is appointed by the Chief Justice with the approval of the other justices. The Supreme Court adopts rules used in the state's courts, including rules of civil procedure, rules of criminal procedure, rules of evidence, rules of juvenile procedure, and rules of appellate procedure. All the rules adopted by the court are found at its website. In addition to live webcasts of oral arguments, archived copies of oral arguments are available on the Supreme Court's website. The North Dakota Supreme Court's website contains the court's opinions covering many years. The site also contains a detailed directory of North Dakota licensed lawyers, biographies of state judges, listings of officials by counties and judicial districts, guides to using the North Dakota judicial system, and links to other legal resources on the Internet. A search feature is also available. In addition, court notices, proposed rules, committees, members, agendas, and minutes are also found on this website. This is Justice Lisa Fair McEvers at the North Dakota Supreme Court. You have reached the proper location for live webcast for oral arguments of the Supreme Court. The live webcast from the North Dakota Supreme Court will begin at the time scheduled. The court's daily calendar is noted at the top of the Supreme Court's homepage. Oral arguments are normally scheduled at 9:30, 10:45, 1:30, and 2:45. 50 minutes are generally set aside for oral arguments. Arguments may go a little bit longer, and sometimes not all the 50 minutes are used for the oral argument. No decisions are announced at the oral argument, as all cases are taken under advisement. The Supreme Court will issue a written decision, usually within a few weeks of oral argument. Written opinions are posted at the Supreme Court website. Anyone can subscribe to receive free email notice of new opinions and other Supreme Court news. Simply click on subscribe on any website page. The North Dakota Supreme Court is the highest court in the state of North Dakota. It reviews the decisions of trial courts, known as district courts, and decisions from administrative agencies. The Supreme Court also decides cases involving the disciplining of lawyers and judges. There is no jury in the Supreme Court, and no witnesses are heard. The Supreme Court consists of 5 justices who are elected for 10-year terms. When there is a vacancy on the Supreme Court, the governor may fill the vacancy by appointment from a list of candidates submitted by the Judicial Nominating Committee. The Chief Justice is elected to 5-year terms by the Supreme Court justices and district judges. The Chief Justice is the administrative head of the state's judicial system. The Chief Justice is assisted by the state court administrator and other staff. The clerk of the Supreme Court receives documents for the Supreme Court. The clerk supervises the court's records in the filing, distribution, and publications of the opinions of the Supreme Court. The clerk of the Supreme Court is appointed by the Chief Justice with the approval of the other justices. The Supreme Court adopts rules used in the state's courts, including rules of civil procedure, rules of criminal procedure, rules of evidence, rules of juvenile procedure, and rules of appellate procedure. All the rules adopted by the court are found at its website. In addition to live webcasts of oral arguments, archived copies of oral arguments are available on the Supreme Court's website. The North Dakota Supreme Court's website contains the court's opinions covering many years. The site also contains a detailed directory of North Dakota licensed lawyers, biographies of state judges, listings of officials by counties and judicial districts, guides to using the North Dakota judicial system, and links to other legal resources on the Internet. A search feature is also available. In addition, court notices, proposed rules, committees, members, agendas, and minutes are also found on this website. This is Justice Lisa Fair McEvers at the North Dakota Supreme Court. You have reached the proper location for live webcast for oral arguments of the Supreme Court. The live webcast from the North Dakota Supreme Court will begin at the time scheduled. The court's daily calendar is noted at the top of the Supreme Court's homepage. Oral arguments are normally scheduled at 9:30, 10:45, 1:30, and 2:45. 50 minutes are generally set aside for oral arguments. Arguments may go a little bit longer, and sometimes not all the 50 minutes are used for the oral argument. No decisions are announced at the oral argument, as all cases are taken under advisement. The Supreme Court will issue a written decision, usually within a few weeks of oral argument. Written opinions are posted at the Supreme Court website. Anyone can subscribe to receive free email notice of new opinions and other Supreme Court news. Simply click on subscribe on any website page. The North Dakota Supreme Court is the highest court in the state of North Dakota. It reviews the decisions of trial courts, known as district courts, and decisions from administrative agencies. The Supreme Court also decides cases involving the disciplining of lawyers and judges. There is no jury in the Supreme Court, and no witnesses are heard. The Supreme Court consists of 5 justices who are elected for 10-year terms. When there is a vacancy on the Supreme Court, the governor may fill the vacancy by appointment from a list of candidates submitted by the Judicial Nominating Committee. The Chief Justice is elected to 5-year terms by the Supreme Court justices and district judges. The Chief Justice is the administrative head of the state's judicial system. The Chief Justice is assisted by the State Court Administrator and other staff. The Clerk of the Supreme Court receives documents for the Supreme Court. The Clerk supervises the Court's records in the filing, distribution, and publications of the opinions of the Supreme Court. The Clerk of the Supreme Court is appointed by the Chief Justice with the approval of the other justices. The Supreme Court adopts rules used in the state's courts, including rules of civil procedure, rules of criminal procedure, rules of evidence, rules of juvenile procedure, and rules of appellate procedure. All the rules adopted by the court are found at its website. In addition to live webcasts of oral arguments, archived copies of oral arguments are available on the Supreme Court's website. The North Dakota Supreme Court